Board.
Hi, this is Elizabeth Townsend. It's August 1st. This is an interview with Judge Eileen Hollowell. That's it. That's the introduction.
There you go.
Yeah, ready. In looking at the handouts for this class, one of the things that you're asked to do is kind of write about your view of life and the law, which is difficult, I think, kind of like a giant explanation of your life, which is not easy. But one of the things was an incident that maybe happened to you in your practice that stands out, either good or bad. And there have been some. The one I'm going to talk about, people who know me won't find this at all surprising, isn't good. But there have been a lot of good things that have happened in my practice, and one of the best things, as far as I'm concerned, is becoming a judge, which I'm really enjoying. But the thing I decided to talk about, I was forced to remember when I applied to become a judge, because when you apply to become a judge, they ask about all the good and bad things that happen to you, including whether or not you've ever been sanctioned or mentioned by name, either for good or for bad, in a written opinion by any court. And I had been a lawyer of just about 10 years when I managed to be sanctioned in absentia by a bankruptcy judge in Texas and have a Rule 11 sanction entered against me. And it was terrifying at the time, and I found that when I went back and went through all of the records to try to explain to the Judicial Selection Committee why this had happened, it was still terrifying. It was still really troubling to me what happened and how it happened. And it took me a long time to write out an explanation for this Judicial Selection Committee, and luckily I had friends who looked at what I wrote and basically wiped it all out and said, just say what happened, say that the sanctions got removed and be done with it, and let somebody else ask you how you got yourself in this situation. But I thought it might be interesting to talk about how you do get yourself in that situation, even when you think you're working hard and doing the best that you can, how it is easy to be perceived as being, if not unethical, at least and if not incompetent, close to it, based on the cold record, and that we sometimes forget that. I'd been practicing about 10 years. I was sort of hitting my stride in my practice as a bankruptcy lawyer. I was the acting head of the department in what was then one of the larger law firms in Tucson, and we had a client, a title company, that we did a lot of business for. They were, you know, one of the stables. They were important to the other partners. I was on track to become a partner. I was trying to develop a rapport with this client. And we were also at the height of a bankruptcy boom that occurred in the late 80s and early 90s that meant the bankruptcy dockets everywhere were very, very busy, in Arizona, in Texas, every place in the world. So this title company calls me up and tells me they have a little problem, that they've had a default judgment entered against them in Texas by a judge I've never heard of because I don't practice in Texas. But feeling relatively confident, I think, well, I know how I can solve this problem. Just send me the file. There's obviously been some misunderstanding. I'm going to get it all fixed. So they send me the file, and we're outside the 10 days for a motion for reconsideration. And the facts are almost irrelevant. You know, I could waste a lot of time talking about the facts, and it's really not the facts that were the problem here. The problem was the fact that I didn't follow the rules, and that I assumed that I knew how the system worked, and I didn't use the rules to make sure that I could make the system work in a way that would be both good for me and for my client. I assumed I could pick up the phone and call the lawyer who obtained the default judgment and get something worked out. Well, the lawyer who obtained the default judgment had no incentive to work anything out, and he had a judge he thought would be sympathetic, and so he said, you know, I'm not going to change the default judgment. If you want to do something for reconsideration, have at it. And so I filed a bunch of pleadings outside the time period of a motion for reconsideration, but inside the Rule 60 time period. I didn't bother to check the local rules in Texas. My client said, you know, this isn't a very big matter, but I think there was maybe $14,000, maybe it was $20,000 at issue. We don't want to have to hire Texas counsel. The partners in my law firm were like, you can handle this right, you know, let's make this client happy. Let's not have to hire counsel in Texas. Let's get this taken care of. So I proceeded just to really muck it up. I filed the motion, I got a notice from the court that the proceeding in which I had filed it was closed. Bankruptcy cases basically have a large administrative case, and inside the administrative case there can be discrete lawsuits, and those discrete lawsuits can be closed even though the case in chief is open. So I moved to reopen the case. Then I file essentially a Rule 60 motion, and then I ask to appear by phone. I run all this through the judge's law clerk. Oh yeah, it's all going to happen. Well, what happens is that the matter gets set for hearing. I'm not allowed to appear by phone. The local lawyer is there. I get hometowned in the sense that the local lawyer, there's no one else there, stands up and says to the judge, "Here, look at this pleading. It's completely inadequate. Doesn't properly plead any basis for relief under Rule 60. They're just trying to keep the money away from this poor little person, my client." And the judge did something that just amazed me, that no bankruptcy judge I knew of in Arizona would ever do. He entered an order imposing a Rule 11 sanction against me, and containing a finding. Let me see, I was rereading it again today. Yes. There was an order to hold my client in contempt, which says that if my client filed an interpleader, then in such event the court shall receive a show cause proceeding, and as to why the title company should not be referred to the United States District Court for a contempt proceeding. Well, as you might imagine, when the client got this order, I was not the most popular associate at my law firm dealing with this title company. The managing partners in my law firm didn't know quite what to do with me or themselves, because now my law firm had been ordered to pay the opposing counsel, $1,250, and I had a Rule 11 sanction entered against me. So I went into something of a tailspin. I immediately hired Texas counsel, which thank God I knew someone. I moved for reconsideration, and 3 months later, everything went away. I had to get on an airplane, fly to Texas, meet with the judge, beg for forgiveness, and then we get an order that says, the court finds good cause for removing all the sanctions, the title company won't be held in contempt, the lawyer is supposed to disgorge the $1,250 back to the law firm in Arizona, and everyone goes away happy. But what it taught me was something that I thought I had learned when I worked for Congressman Udall in Congress, and something that I know to be the case, which is follow the rules. The rules are your friends. They're not your enemies. Figure out what the rule is. If you figure out what the rule is, you'll find a way to do what you want to do. Secondly, pay attention. What was happening when this case happened to me was I had a lot of balls in the air. I figured if this case had happened in Tucson, Arizona, in front of a judge I knew, I could take care of it on a simple request for status hearing to clarify the record. But that's your local practice. What you do in your local practice may not be what somebody does in another city under a different set of rules. And we have increasingly national practices, especially in specialty courts, bankruptcy courts, tax courts, and in litigation practice, depending on the securities litigation. People have a national practice. And so if you're going to get involved in that, detail does matter in the sense that you have to know how to present your package. That you shouldn't assume that what works normally in your practice is going to work someplace else. And you should always assume, even when it seems like it's not something particularly important. I think there was a part of me the whole time this case was going on that kept saying, this is over $14,000. This is ridiculous. We ought to be able to resolve this. And I wasn't respectful enough of the position of my opponent, who, one, had the upper hand, but also who believed strongly and convinced the judge that my client and I were basically defying the rules because his client was impecunious. He had the debtor, I had the title company. There are all kinds of shorthands that courts use to understand these types of situations, and I thought of that in the past week when I had a pretrial and I had a consumer lawyer and a national law firm on a lawsuit, and the consumer lawyer has requested discovery and the national law firm is presented him with 20,000 pages of documents. And I say to the lawyer for the bank, you know how this looks. you know exactly what this looks like if you're sitting up here. I've got essentially a sole practitioner who served you with a discovery request, and you've buried him with 20,000 pages of documents. That won't work. You are going to have to give him more specific information about this loan. Well, I did the exact same thing in a way in this case. I had the title company. I forgot that for the judge sitting in Texas looking at a cold record, he's looking at a consumer debtor and a consumer debtor's lawyer trying to get money into a case to make the case work, and being strong-armed as far as they can see by some rich title company and some large law firm lawyer in Tucson, Arizona. So I think that was in many ways definitely one of the most difficult things that happened to me in my practice. And interestingly enough, 10 years later, when I applied to become a bankruptcy judge, I still find it very difficult to write about it in any kind of coherent way. And I find it difficult to talk about it even in any kind of coherent way, because it still kind of disturbs me how things can mushroom out of your own control. I mean, lawyers love to have control. You want to have control of the situation. You want to think that you're going to be able to craft some solution. So you're on the phone and you say to this very important client, yeah, I can take care of it. It isn't going to be any big deal. And then you're caught by your own statements, the fact that you maybe didn't analyze things carefully enough. You told them they weren't going to have to hire a lawyer in Texas. I mean, no matter what happened, this was a disaster for my client. They ended up, I mean, I had to write down a bunch of my fees, so my partners weren't happy. But we had to pay the lawyer in Texas. And, you know, it cost the client a lot of money. And so that's my story.
Can I ask you one question? It seems like you'd be afraid that would happen at any moment, that could happen with anything at any time. I mean, that you do the best you can. Do you think that that's something to be fearful of in terms of getting a Rule 11 sanction, especially as a young lawyer?
Well, the one good thing that happened for me here is under the rule, the lawyer has to have some warning. So on appeal, this judge would have been overturned, and you know, I went and did my research, and he had a reputation for being kind of, you know, having a quick, you know, he had a flashpoint, and I had hit it, you know, inadvertently. But typically, you can't get a Rule 11 sanction imposed against you under the rule without there being some warning. And in fact, judges are very reluctant to do it. I mean, that's one of the complaints I hear from the bar. It's one of the complaints I had when I was a lawyer, is judges don't do enough to enforce the rules. And in order for there to be this more civil tone, which, you know, I have kind of mixed feelings about that, you know, judges have to step up to the plate and be willing to enforce the rules. So I don't think, what young lawyers should be wary of is developing a reputation for either being too quick to anger or too quick to come to the wrong conclusion, because your reputation is what follows you around in your practice. And there's a lot of time demands made on lawyers, and they're busy. And this was a kind of a classic case of me telling an important client what they wanted to hear. First of all, how did all this start? Well, the client screwed up. The client allowed a default judgment to be entered against them. And it would have been better if instead of saying, oh, don't worry about it, Mr. Title Company, big important client, we're going to take care of this for you, I would have said something like, send me the file. Let me take a look at it, and then let me talk to you. But what I did was I said, I'm sure we can fix it. Send me, you know, the last, you know, I don't even know that in the beginning I had enough sense to ask for the whole file. You know, I had a lot of other things on my desk, which is what happens to young lawyers. You have a lot of other things on your desk. You're busy working on a lot of other things, and this is like just one more thing, and it's like, okay, how can I get it off my desk? And you do want to be able to work efficiently. Clients can't afford for you to spend, you know, 10 hours on every project that maybe you could do in 1 hour. But one way you get to the point of being able to do something in 1 hour is you develop a reputation where people know that you're competent and that you're trustworthy. And you can be, no one can be competent coming out of the box except extraordinary people. And there are extraordinary people. You know, there are those people who come out of the box who are just unbelievably good. But most of us aren't. Most of us have a learning curve, and, you know, that's just the way it's going to be. And I don't think new lawyers, whether they're young or middle-aged or whatever, should be afraid of saying, you know, I'm not sure, I don't know, let me get back to you. Then you have to get back, especially to clients. You know, there's the whole thing about keeping clients happy and telling clients what they want to hear is, I think, a real tough area for all lawyers, and especially for new lawyers, where you want to be able to go to the partners in the firm, or you want to be able to, I think, on your own, build a client base and have clients have confidence in you. And I know a lot of very good lawyers who still have trouble telling clients no, and still have trouble saying to clients, you know, this isn't, you know, you're not being realistic about what you want. And that takes time. And sometimes clients have to go through a process of their own, and it's not really up to the lawyer to tell them no. But there are places where it absolutely is up to the lawyer to tell them no. So, you know, and that's what, I mean, I think law schools now, and certainly with all these professionalism classes, there's all kinds of examples of when the lawyer has to take control. And the lawyer has to be in control of the process. That, to me, is, I'm adamant about that. The client doesn't get to control the process. The client doesn't get to tell you that you won't give somebody an extension of time on discovery. You know, that's the kind of professionalism the lawyers have to keep a handle on. No, I don't think lawyers should be too afraid of Rule 11 sanctions, but they should be afraid of not taking enough time. You know, they should be afraid of making the mistake I did, which is to tell people what they want to hear. You know, we're all conditioned to do that. You know, we all want to tell people what they want to hear. And sometimes when clients come to you, they've really bollocksed it up. And the only real answer is to say, you know, I'm not sure, or even more importantly, this is a big mess. We should hire a lawyer in Texas. I can't do this for you from here. Yeah, it's going to cost you more money, but you know what? That's just the way it is. Some things we can't fix.
What did you mean about mixed feelings about Civil Town?
Well, there's a part of me that thinks that lawyers don't need to be lectured. You know, that there's something condescending about telling lawyers how they need to behave, as if they're teenage children who don't know when to behave or how to behave. And sometimes I feel like lawyers are being talked to the way I would talk to my sons before I would take them up to visit my father. You know, when we go to see my father, your grandfather, you will dress correctly, and you will not put your face in the soup, you know. But on the other hand, there have been, you know, real abuses, and I think a dialogue about how lawyers are perceived or how lawyers treat each other isn't a bad thing. But I'm not convinced that you can impose this stuff on people. I think it's got to be sort of a culture that you know is there. And I've been pretty fortunate because I practiced in a small bar, and it isn't because people who practice in a small bar are inherently more civil to each other. It's that they have no choice. What goes around comes around. So you're going to see these people again, and when you know you're going to see them again, you are sure to be sensitive to the fact that if they ask you for something, you try to accommodate them, because you don't know when you're going to have to ask them for something. At the same time, you get people like Burr Udall, or who comes to mind, who's somebody, or Richard Davis, guys that have practiced in this community for years, who rarely, if ever, will allow themselves to get into an argument over things like discovery, because they understand that at the end of the day, they will be perceived by the court and by the jury as so much more reasonable than somebody who's going to say, you know, I want it by this deadline and you better do it, or send snitty letters. The whole snitty letter thing seems to me to accomplish very little. And really, I didn't see that in my practice very much. But again, I practiced in a well-defined area.
How does the role of a judge, what is the role of a judge in all of this in terms of creating do you have it?
Well, I'm still trying to figure that out because I haven't been a judge for very long. I had to do a professionalism class up in Phoenix, and what I said to people there is, I said, what I notice on the bench is that, you know, you're sitting up there and you see the tip of the iceberg. You know, the iceberg kind of goes this way and that way in the case. And I said, if the lawyers don't tell you what's really going on, it's hard for the judge to help. On the other hand, I think lawyers are reluctant to let the judge come in. You know, when I was a lawyer, I really never wanted the judge to decide anything. My idea of a successful case is a case that I ran, I decided, I got done, and I took it into the judge and said, please sign the compromise and we'll see you later, goodbye. Because you never know what the judge might do. As the trier of fact, they can really muck it up, and they can. I think it's your job to maintain a level of professionalism in the courtroom. And that can be hard sometimes. You know, sometimes I'm learning that you can't tease people when you're the judge. You got to be careful about that. And you got to keep your sense of humor, or at least my version of a sense of humor, in check, because things that you say now that you used to be able to say, people might take the wrong way. But certainly you can let it be known that you expect people to treat each other civilly in front of you. And very few lawyers act out in front of the judge. I mean, sometimes, but it's pretty rare. But the other stuff that goes on, the letter writing, the hassling, the slammed phones that can happen in a tough case, you know, the judge doesn't really know about that stuff. And the judge isn't going to know unless one of the lawyers comes in and says, we need your help at a discovery conference. This just isn't working for us. But I do think that the judge has to be more willing to hear some of those types of arguments. You have to not say, I don't want to have any discovery disputes in my courtroom, because then the litigants don't feel like they have any place to take it. And of course, it's easy for me to say that. I'm a bankruptcy judge. We don't do discovery in bankruptcy. I mean, it's, you know, so I don't get a lot of discovery disputes. It doesn't happen in my courtroom much. I mean, occasionally, but not a lot.
I had another question. I really liked your narrative that you sent. It was really, I really liked it a lot. But I had one question. Being 33 when you started, and now you're a judge, and there's lots of things in it, but I thought maybe you could talk a little bit to the older students who feel like maybe they don't have as much opportunity, or that they don't get as much, you know what I mean, like they don't have as much time.
They're lucky. You know, when I went to law school, I used to go out with some of my classmates who were going straight from college to law school, and I thought, geez, you know, how can they do that? They're going to be so burnt out by the time they're 45. And I think some of them are. I think, frankly, some of them are. You know, law is really great training for a lot of different things. We like to say it's not always clear what that means, and it's not always clear that there are going to be all these other opportunities opening up. When I was in law school, the job market was actually much, much tighter than it seems to be for law students now. I mean, there seems to be plenty of work for lawyers. But it's not always the kind of work that everybody wants. You may, you know, I had 2 kids. I never thought I was going to do anything except essentially do some kind of public work. That was my vision when I was in law school. I wasn't interested in working 60 hours a week. I wasn't interested in being a partner anywhere. I don't know why I didn't know I was on my way of getting a divorce, but in my mind I wasn't going to do that, and I was going to practice law in this civilized way, and I was going to work 35 or 40 hours a week, and that was going to be a 9-to-5 job. That's hard to do as a lawyer, even when you're a government lawyer. I mean, I like to joke that I was the Elizabeth Taylor of law firms, looking for the right place and the right position, you know. And so I've been a lawyer in a lot of different contexts, all on the civil side, but I've worked in big law firms, medium-sized law firms. I've worked for the state. I've worked for myself. It's a real demanding job, but I think there are plenty of opportunities to practice law outside of traditionally just, you know, joining a firm. Having said that, I think it's hard. I think it's good to get training. I think that I was fortunate to work some of the places I worked and to get a picture of how the process works as a business, because it is a business. You know, you can't really do it for free unless you have some other source of income. But I don't think, I was aware, I felt I was a lot older than a lot of my classmates, and I felt that limited my options somewhat, but in reality it never, I don't think it ever really did. But I was in my 30s, you know, I don't know what it's like to graduate in your 50s, and I didn't always know I wanted to be a judge, although somewhere in the back of my mind I knew I would like it if I would be so fortunate as to get that job, because it's a great law job being a judge, no doubt about it. You get to, it's like going back to law school. You get to think about the law more, in a more neutral fashion than you ever do when you're practicing, because when you're practicing you have somebody that you're an advocate for, and you're trying to solve their problem, and you're also trying to get the law to if not bend in their direction, you're trying to use the law to assist them. And when you're in law school, you get to look at the case and say, well, what's the holding of the case, and how does the law apply to the facts? And that's what you get to do when you're a judge. And so that's probably why I like it. That's why I liked about law school. But I don't know what else to say about the whole being older thing. I think people shouldn't be too concerned about not knowing exactly where it's going to fit, because it kind of plays out. I mean, when I started law school, I think I assumed and everyone else assumed I'd end up doing family law. And somewhere at the end of my first year, I thought, you know, I'm not ever going to do family law. It's just not what, you know, I don't want to go to juvenile court and do custody disputes. It's not what I want anymore, and I just moved on from there. But really, you know, I became a bankruptcy lawyer by accident. It's an area of practice that was really hot when I first started practicing law, and they needed a body, and I liked it. It, you know, it was something that I was attracted to because it was a negotiated practice, and that's the kind of stuff I enjoy. So who knows? You know, you get out of law school, your first job or your second job may not have anything to do with what you ultimately end up doing. That's what I've told a lot of associates I've had over the years. It's what I tell my law clerk now. I say, you know, it's great to come and clerk at the court, but don't assume that you want to be a bankruptcy lawyer. You might not want to be one at all.
I have one more question, and it's actually your question. In this narrative you wrote about the role of a counselor, and you wrote a number of questions, but I wanted to know the answers and what you thought. So you had said that the role of a lawyer, or the counsel role of a lawyer, was barely addressed in your legal training, and that you found that to be the most problematic in the beginning of your career. And then you have these questions. How does an inexperienced lawyer deal with a client's expectations, especially if those expectations are unrealistic or include demanding the lawyers do things which may be unwise, expensive, or even unethical? And it kind of ties back to the stuff you started with at the beginning.
You know, what I think the answer to that question really has to be that first, in law school, students have to be told this is going to happen to you. And it's going to probably happen to you pretty quick. But I think the clinical programs you guys have running now, I mean, there were no real clinical programs available when I was in law school, or very, very limited. There were some 2080s, but they were never at a time I could take them. And now, so there are more clinical programs, so you can get more hands-on experience with real clients, which I think is good. But the other thing is that in the ethics classes and in continuing education, we have to emphasize that this will happen. That I can't think of a single lawyer I know that hasn't confronted this situation fairly early on in their practice. And then hopefully either they're at a firm where they feel like they can go to somebody, although you have to be careful about that. Let's say you're at mega firm and you've been assigned a mentor. Well, be careful about that. You know, confidentiality inside the law firm may not really exist in that situation. I'd be very reluctant to say to new lawyers, yeah, you can go talk to your supervising partner about this. I would say, be careful who you trust, but trust somebody. Find someone to talk to. And you're under ethical constraints, so do it in the abstract, but support groups are important for lawyers, and it was very important to me, and some of my best friends are still people I went to law school with here, and people I've always been able to pick up the phone and say, this is really bothering me, what do you think? And they're still, I haven't always agreed with what they've said, but those friendships, building those, and you know, not just with your fellow students, I mean, I've picked up the phone and called law professors, and out of the blue, who've been very nice about it. Of course, we're talking about people like Dean Ayers or Dan Dobbs, but they've been willing to listen. And they don't necessarily have the answer, but then that helps you go back to it. And the bottom line is sometimes you have to be willing to let clients walk out, or you have to be willing to face the fact that maybe this isn't the law firm for you, or maybe this isn't the practice for you, and that doesn't make you a failure. It just means this isn't, not everybody can do criminal defense work, not everybody can do custody law, not everybody can bear bankruptcy law. It's not all fun. Lots of it is really, really hard work because people are bringing you their problems. So just like social workers or psychologists or anybody else, you're dealing with situations which, for better or for worse, people can't work out for themselves, even on the commercial side. You know, complicated problems with a lot on the line. You know, I remember once driving back from a settlement situation, and I had a check for $1.8 million in my purse, which is more money than I'd ever seen in my life, and being sort of just amazed that anyone would trust me with anything like that. And the way the day started was, we walked into this meeting, and in 5 minutes my client wanted to walk out, and in 10 minutes I wanted to walk out too. And luckily there was another lawyer there who said, no, don't leave yet, wait, let's just wait, it's early in the day. You know, and 13 hours later we had a solution. That's hard stuff to do. You have to be patient.
And how do you not take it home, or do you take it home?
Oh, geez, you know, I certainly wouldn't have that. You know, if you were to interview my sons, they would do this imitation of me of how the car would pull into the driveway, and I would be yelling at them before I got out of the car. I think you do take it home. I think it's very hard not to take it home. I don't have any words of wisdom about that. I think that you have to expect to take it home, and then try to work around the fact that you're doing that, and you know, set your priorities. I mean, I took it home, but my kids got to soccer practice. I took it home, but we went, you know, what's a normal life now? I don't know, but you know, I didn't just work. I made time for my kids, and probably more time at times than they would have liked. There would have been times when they would have just been as happy if I'd stayed at the office.
How do you do that? I mean, do you just take the time? And
yeah, you just sort of say, and I think again, as more women have gotten into the profession and as things have changed and people, there's a lot more talk about family. When I was a single parent and a new lawyer in the same year and probably clinically depressed, but never mind, I used to hire a babysitter and go in on Saturday nights, and I'd work on Saturday nights. Because, you know, then it was quiet. Then I could think. And, you know, I didn't do it all the time, but I did that some. But I also then would, you know, made it clear that at 5 o'clock I had to leave. And then I'd come back. And now you can telecommute. But I also did things like, you know, I remember once Hattie Babbitt, who I didn't know at all, but her kid was on the same soccer team as my younger son, and she called me one day. She said, I have to be in court. I know we don't know each other. Would you pick my kid up from soccer? I said, sure, absolutely. And I did that all the time with my kids. People I barely knew would be picking them up from baseball practice, or, you know, I would have colleagues in my law firm who would go out to the baseball field and say, your mom sent me for you, and my sons would go, okay, fine, whatever, we going by the Burger King? Alrighty. And you have a kind of a collegial family. Everybody is, some firms are more family oriented than others. I mean, there's the whole issue of, can you be a successful lawyer and a mother, and some people can, and they're always, but it's important not to put those people up as the prototypes, because there's, you know, there are really only so many hours in a day, and sometimes the trade-off is you're not going to become a partner as fast. Maybe you don't want to be a partner. I know a lot of women, I think, from my class, and who kind of opted out of that. And if you look at kind of where people went, a lot of women went into government work for a good reason. The work was more rewarding. They got to go home at 5 o'clock or 6 o'clock. Or there were different expectations. But I also know women like Susan Boswell, who, you know, grew up in Stafford, Arizona, and is a powerful person and a, you know, very successful lawyer with a very successful marriage and 2 grown sons, and, you know, I mean, there are all kinds of different ways that people can make this profession work, and the important thing is not to make up your mind that you have to be one or the other, but to kind of, what's the term in basketball, let the game come to you? There's a lot of that about practicing law. You know, most people, a lot of being a successful lawyer is showing up, listening, and doing the work. That's a lot of what being a successful. You know, there are the brilliant minds. Most of them are teaching in law school. Thank God. I'm always thanking Toni Massaro that she's not in private practice. She would have made us all look terrible. But a lot of it is just showing up and being there, and being willing to show up day after day and do it. And in time, people will come to recognize that they can depend on you, that they can send clients to you, and that they can trust you. And you can decide how much of that you want to be driven by. It's only money, we like to say. Easier said than done, though. One of the things I think that's really tough is that there's a culture among lawyers of overwork. And maybe that's going to change, and maybe it is changing, but it does lead to lawyer burnout. I mean, how many really good litigators do you know who are over 50? There are not that many. It's because it's really, really hard work.
Do you have to overwork? I mean, we've just talking about ways you can.
I don't know, your dad was a successful lawyer. I don't know the answer to that question. I think, you know, it's a conversation I have sometimes with some of my friends, which is that you can also get addicted to the adrenaline rush, the multitasking, the 15,000 things to do at once, the emails, the phone. There's a dynamic to that can be seductive. And if you like it, I don't think you need to apologize for that. But if it's wearing you out, then no, I don't think you have to. But there's a trade-off. You're not going to have as much money, and maybe you won't have as much prestige. Maybe you won't be learning to say no is one of the toughest things for most people, whether they're lawyers or not. It's just in the lawyer environment where there is this culture of, sure, we can do it, and we can do it better and faster, and it's sort of the macho thing. I billed, over a gazillion million hours last year.
All right, I have another question. It's a couple of silly questions, and we'll be done.
Sure.
Do people treat you differently outside of court now that you're a judge?
Oh, God, I think so. I hope my friends don't, but here's my favorite example of that so far. I ride the circuit a little bit, and I go out to an outlying town that will remain anonymous. And my predecessor would go out there, and he'd hold hearings, and he'd be done in 2 hours. And the other judge, Judge Marler, and I started going out there, and it was like we actually sent them a memo that said there's a new sheriff in town, and the rules are going to apply and all this stuff. And these lawyers were not happy, and they invited me out to lunch, and they were really not happy, because for lawyers who don't know you very well to complain to you when you're a judge is pretty exceptional. And they were like, we don't think you understand the culture here. And I'm like, okay. So I thought that was pretty good that they were telling me, what they really thought. But there was one lawyer, he was like, but, oh, Judge, there's no doubt about it. Things are so much better now. And you just want to say, oh, give it a rest, All your colleagues hate it, and you hate it too. So don't think that that's... But it can be more subtle, Bankruptcy judges are, we're pretty lucky because it is a small bar. And both Judge Marler and I practiced in Arizona, and I practiced in this town before I became a judge. Hopefully my friends would let me know if I stepped over the line. But the fact of the matter is, no one has an incentive to tell you the truth. You shouldn't ask people how you're doing. What else can they say? Oh, you're doing great. We love having you. Oh, it's wonderful. So yeah, I think that you get treated a little bit different. But not as extreme as it probably is when you go to Superior Court, and certainly not anywhere near what it must be like to be a district court and Article III judge. Where there, I think it's the whole thing about the judiciary should be independent. Well, then how do you make the judiciary accountable? How do we get any feedback? And that's something I'm actually pretty interested in. I'd like to see the bar develop some questionnaires. But early on, a friend of mine did take me out to lunch and gave me some feedback, and I didn't like it. It was like, what? But I didn't. I thought I held it together while we were having lunch, and I went home to my husband and I said, God, imagine so-and-so complaining about me this way. And he said, you asked her what she thought. What? I'm like, well, again, I really wanted to know. Yeah, it's a problem. It's a problem. Judges, have to not take themselves too seriously, I think.
And it's related to that. Do you feel differently now that you're a judge?
Sure. The biggest change is I have no clients. I say this all the time, sort of like it's a hackneyed phrase now, but it's a short food chain, but I'm at the top, and maybe we ought to take that out of here. I wouldn't want anybody to. Yeah, what I feel differently about is just that I didn't get the life law balance down very well, and I did work really, really hard. Not always very, very successfully, but I felt a lot of pressure a lot of the time that I was practicing law, and I don't feel that pressure now as a judge. When I go on vacation, I'm on vacation. I don't call into the office. I don't worry about my emails. I'm gone. The only time I had those kind of vacations as a lawyer is when I was in between jobs. Otherwise, it's really hard to leave. Even when you leave, like when I for my 50th birthday, I gave myself a trip to France and invited a bunch of people I knew. And I never called into the office, not once, because I rented this house in the south of France, and by God, I was going to have a good time. But I thought about it. I thought about work. I didn't call, but I thought about it. I've been away twice now since I've been a judge, and I didn't think about it once. So that's a big change.
Okay. Interesting. All right, and this is our dorky question. People interpret it differently. In fact, someone said it was a bad word to use the last time. What are one or some of your happy moments in law? And people have gone all over the place with it. So.
Well, it's me too long a story. One of my favorite moments as a lawyer was we had a case. I was an associate, and I had John Malloy, who was Judge Malloy, and he must be in his 80s now, and he was in his late 60s then. We had a case where we represented a Filipino affiliate of Learjet, and it was being heard by a senior status district court judge who was here as a visiting judge. And our client had gotten a judgment in the Philippines against Learjet, and then there were all kinds of other things about defective airplanes and stuff. And so my job was to write a memorandum and prepare an argument about why the district court ought to grant comity to this Filipino judgment. And it involved wandering around the basement of the law school, finding the Philippine law reporter, which, Philippine law is really interesting because it's like a mixture of civil and common law. So there was a reporter but no index, and I had a great time. I loved coming down to the basement of the law school reading the Filipino law reporter. But I had very little hope. I had really very little hope for this motion. But I wrote it all up, and we flew to San Francisco in Judge Malloy's plane. The paralegal, a guy now who appears in front of me who's up in Kingman, and we flew to San Francisco to do this oral argument, and because the judge was coming down from wherever he was up in Oregon, I can't remember his name now, and we ended up doing the oral argument in the cloakroom of the San Francisco District Courthouse because there were no courtrooms available. So we're in this kind of conference room that's also a cloakroom, and there's Judge Malloy and Judge Tinney, who was then at Bilby Shown here, Mick Rusing, who's the head of a very successful law firm in Tucson, our client who joined us in San Francisco, me and the paralegal, and going down the table with the judge at the head of the table. And so the first part of it is that Judge Tinney and Judge Malloy are arguing the motion for summary judgment about defective airplane parts. It's all I can do to stay awake. But I'm really nervous. I'm very, very nervous about what's going to happen on this comedy argument. So we get to the comedy argument part, and the judge seemed very old to me then, and I was already in my 40s, and now that I'm in my mid-50s, I'm sure he was only like 70, hardly any age at all. And we start in on whether or not we're going to grant comedy to this Filipino judgment. And it was right at the time when Fernando Marcos was in the paper, and the shoes and the whole thing is, and Mick Rusing brings out this newspaper and he drops it on the table and he says, you know, this is just absurd, Your Honor. How could we think about, you know, granting comity to a country like the Philippines? The judge sits up very, very straight, and he says, "Are you suggesting, sir, that the Philippines is not entitled to be viewed as a civilized country?" And, you know, I can sort of see Mick starting to back up, but what can he do now? You know, and he says, "Well, Your Honor, it just sort of speaks for itself." And he said, "Well, I spent 20 years in the Philippines, and my client is starting to jump up and down. You know, he's just so excited. He's just like," and all I can do just not to laugh myself under the table, you know, and I feel sorry for Mick, and and it's just trying to stay in control throughout the whole thing. And so finally, after the judge has dressed poor Mr. Roosing down, he turns to me and he said, "Do you have anything to say?" I said, "Do you have any questions?" He said, "No." I said, "Then I have nothing to say." And all the way back, Malloy just, you know, chastised me. Why didn't I make my argument? Why didn't we know this judge was in the Philippines? I said, "Listen, you get a gift horse, you don't look it in the mouth. We won. I don't care. You know, I don't care why we won. I just know we won." And sure enough, we did win. So that was absolutely one of my most fun times as a lawyer, and it had really nothing to do with anything I did. It was just, you know, the absurd meets the law. It was fun.
That's a good story. Well, do you have anything else before we wrap up?
No.
Oh, this is great. Thank you so
Great.
much.
It's going to be a lot of work for you. So what's your background coming into this, other than that your dad was a lawyer?